Now let's talk about homeless policy across the West. The reason you see so many people camping along our freeways and in our neighborhoods or cities, well, it's because local governments are forbidden from enforcing camping bans if they don't have enough shelter space available for homeless people. The rule tying the hands of local government comes from a federal Ninth Circuit Court of Appeals decision called Martin versus Boise. It involved a case from Boise, Idaho, but see this map? The federal Ninth Circuit covers a lot of territory, from Alaska down to Nevada and Arizona and Hawaii. And that one case impacted everyone there in the shaded states. Millions, tens of millions of people, and every local government in every one of those states. In that case, the Ninth Circuit said it was cruel and unusual punishment to ban homeless camping for people who are homeless against their will. Now, lawyers trying to reverse that have argued the Ninth Circuit simply got it wrong, that cruel and unusual refers to gruesome things like cutting someone's body into 4 parts, or that's known as quartering, or maybe cutting off their ears or other nasty punishment like that. The sort of stuff done under the rule of King James II in England in the 1680s. Seriously, that's what they say it's talking about. The lawyers say that term, cruel and unusual punishment, actually comes as a reaction to some of the king's punishments. The founders of the Constitution put those words in the 8th Amendment, and it's prohibited. So, if taking action against homeless folks is cruel and unusual punishment, then of course you cannot do that. Which is why you see homeless folks camping everywhere. Now, in 2019, the city of Boise asked the U.S. Supreme Court to overrule that lower Ninth Circuit Court, but the Supreme said no. So it still stands today. But you may have noticed this group, a little different than it was 5 years ago. This is the Supreme Court, and it's now more conservative. And now the Supremes have agreed to take up not Boise, but a different case with very similar facts, and it's from Grants Pass, Oregon. If the High Court reverses the lower court in the Grants Pass case, it would effectively be throwing out that Boise ruling as well. And that would open the door to significant changes in the West Coast and in communities throughout these states to deal with homeless campers. Those who represent the homeless, well, they don't want it changed, and they argue that it is cruel and unusual to punish folks for being homeless against their will. So that's why all of this is important. Now, the latest development is the filing of this brief for the petitioner. It's fancy legal work that says basically it comes from lawyers who represent the city of Grants Pass. And I'm telling you about it because it basically lays out the legal argument the city is making in the case and giving us all a sneak peek on how they're going to argue this thing. The filing lays out the facts of the case. First, the city of Grants Pass has about 38,000 people, and it's in Southern Oregon. When the case was filed, it had 602 homeless people, and all of them became part of a class action lawsuit against the city. The lower court found that none of the shelter spaces in Grants Pass qualified as shelters under the Martin versus Boise case. That's because 138 beds available at the Union Gospel Mission had substantial religious requirements, so they wouldn't count that. It also did not count nearby campgrounds on federal land because, well, it was outside the city borders, so that doesn't count. It also did not count a warming shelter because it was not open year-round, and it did not count a sobering center because it lacked beds. So, the court ruled that without adequate shelter for those 602 homeless campers, you can't punish them for camping in the city limits. What was the punishment the Grants Pass was handing out? Well, the city passed 3 ordinances. One prohibited sleeping on public sidewalks, streets, or alleyways. A second prohibits camping on any sidewalk, street, alley, park bench, or other publicly owned property. And a third prohibited camping in city parks. Now, people who violated those rules could get a $295 fine, which could be lowered if someone pleaded out, or could also go up if you were a repeat offender. At the top end, folks could be hit with a $1,250 fine and 30 days in jail. In its filing, the lawyers say the city of Grants Pass issued fewer than 100 of those fines each year from 2013 to 2018. All right, so that's where things stand now. How will lawyers who want to overturn the case argue? Well, it's simple. They're arguing the 8th Amendment prohibited cruel and unusual punishment, prohibits certain types of punishment, not any punishment. The lawyers write, the amendment states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Nothing in that language, they argue, immunizes certain conduct from all forms of punishment. So are you following me on this? They're saying that the Eighth Amendment is focused on the punishment, not the crime. And that when it comes to punishment, it only outlaws, those nasty types of punishment. They write, the framers shared their English forebears' concerns about barbarous punishments, such as quartering, public dissection, and burning alive. Good heavens. And they point out the Supreme Court in the past has banned death by firing squad and hard labor in chains. But they argue neither the civil fines imposed by the petitioner in Grants Pass for violating ordinances regulating camping on public property, nor the short jail terms for several violators are cruel or unusual. And then, because lawyers love to cite history when it helps their case, they point to a case way back in 1867 when the U.S. Supreme Court rejected an Eighth Amendment challenge to a fine and 3 months in jail. The court back then said the fine and the jail term were not cruel or unusual. And the modern day lawyers wrap things up by saying fines and jail time, that's a punishment that is universal, not unusual, and in the criminal codes of every state and every part of the federal government. The U.S. Supreme Court is scheduled to hear these arguments on the case on April 22nd. Their final decision will likely come, months later, but we'll be watching. And in the meantime, we want to know, what do you think about the case? Do you think passing laws against homeless camping is a way to help solve the homeless issue? Or do you think it's a dead-end road that won't make much difference anyway? Email us, will you? Let us know. Our address is thestory@kgw.com, or you could call and leave a voicemail. The number is 503-226-5090.